and I'm speaking to Mr. Philip Rosenthal. And we'll be talking, he's the director of the, let me start again. He's the director of the public advocacy group called Christianview Network. And we're talking about this issue surrounding what the South Gauteng High Court here in Johannesburg had to say about spanking your children. And it's something that obviously touches many people on their studio, so to speak. So 011-883-0702. Alternatively, you can drop me an SMS on 31702. Hashtag Talk at 9. Obviously, you can get a hold of me there, either on Twitter or Facebook. Happy to hear from you guys on that. And then 072-702-1702 for WhatsApp messages. You can send both a text as well as a voice note. Those would be appreciated. No Facebook. No WhatsApp calls, though. I can't take those. But if you do drop us a voice note, do keep it short and sharp. I do ask you for that. So without any further ado, let's hear from Mr. Philip Rosenthal, who's the director at Christianview Network, about what the South Gauteng High Court had to say about spanking your children. Philip, good evening, and thank you for joining us.
Hi there.
Hi. So, in short, can you just explain what does this judgment basically mean for parents who choose to chastise their children through spanking, through, I don't want to use the word beatings, because beatings is obviously has a negative connotation to it, but I mean through spanking. And I think that I'll try to keep it also within the ambit of reasonable, or what we previously understood as a reasonable chastisement in the form of spanking.
Okay, well, this judgment brings up several different issues, and I hope we'll cover all of them over the course of the program. But
sure.
Just to summarize, the particular case was, from the evidence, seems to be one about abuse and not about normal parental spanking. But what this particular judge, Raylene Keightley, has now said is that basically the normal spanking that is used by almost all parents in South Africa can no longer be defended by the common law defense of reasonable chastisement, which is what made it, has kept it legal for now thousands of years. Now, we would argue that this is completely illegitimate. She's attempting to justify this in terms of the Constitution, but that it is not a legitimate judgment. We would hope that it would be overturned and reversed in the future. But we would say that this is a very serious abuse of power. But there's two real debates here. The one debate is around the question of whether spanking is a legitimate form of discipline, but the other debate is that whether this action of the judge is legitimate or not, and we would argue definitely not.
I mean, look, it is a very contentious issue, and I mean, there's a couple of things that it immediately touches on. Is obviously what is the definition of abuse, what is the definition of corporal punishment, or what role corporal punishment has to play within the home. And immediately, I mean, launching into that, Philip, you and I both know that constitutionally speaking and legally speaking, we've removed corporal punishment from the school setting, right? Which already, is already raises a question and an issue, because surely this judgment then speaks to that very issue then, that because on the basis of, or on the notion of impacting on dignity, unfair and unjust punishment, being exacted against another person. I mean, surely isn't that what we can read into this particular judgment? And that's the rationale behind this judgment for saying, well, you shouldn't be able to spank your child at home.
Okay, well, I think there's more than one issue that you're raising here. One is the specifics. The second issue is that we would argue that the judges have been incrementally abusing their powers for a number of years, and that this was also a wrong decision back in year 2000. We would argue that the legitimate powers lie with the parents, that if the parent authorizes the school to do so, then that is legitimate, but the school shouldn't have that right independently of the parent without their consent. But this judgment is much more radical than that judgment because this is directly taking or interfering with what is happening inside the home. Now, traditionally, in Western legal theory, one looks at the government as being a sphere, the civil society being a sphere, the church being a sphere, the family being a sphere. This is now the courts, which are an arm of the government, interfering with the role of the family directly, which is usually regarded as a sacrosanct area. And so we would argue that this is a very serious abuse of powers, and that this problem of abuse of powers affects many other issues. It's also affecting for example, the dacha issue at the moment, the euthanasia issue, and these judges are taking away attempting to usurp the powers of the legislature and to make a law where they actually have no right to do that. And it actually becomes, there's two options. Either the higher court judges can overrule this, or the public needs to speak out against this and have these judges removed, have constitutional amendments to correct these wrong judgments that they've made. But we've really got a very difficult situation here. And I would compare this to what happened with Nkandla, where each president started to spend more money than the previous president on security upgrades, and eventually it reaches the point where it's absolutely ridiculous, where you have 250 million rands spent on security upgrades. These judges are supposed to be allowed to make minor incremental modifications to the common law in developing it. Here you have a completely radical change, which is not the role of the judiciary. That's the role of Parliament.
So we'll touch on that, because I mean, you're talking about the judiciary infringing on what happens within the home. I mean, I would put forward the argument immediately that that's what the courts have had a right to do, in essence, for quite some time. I'll cite a couple of examples in just a few minutes. But, I mean, what I want to get back to, though, is this specific case, because what we found here was it was a father. I mean, obviously, I presume that part of his argument was a religious basis one, at least. But it was a Muslim father that found his 13-year-old son had gone to certain pornographic sites. The father was obviously very upset and, proceeded in beating the child, in this instance also kicking him and doing other untoward things. But I mean, in my opinion, this was an abusive case and perhaps not the best example for what would be reasonable chastisement. Is that an argument that you would put forward?
We'd fully agree with that, and we wouldn't want to defend the actions of this particular person. The doctor's report showed 4 injuries 4 days later, bruising and an injury on the chest and the shoulder. That definitely doesn't sound like reasonable chastisement. If there's going to be something that's showing a lasting injury, that is not reasonable. But the second point you raise is about the religious argument. Now, interestingly, this particular father didn't raise a religious defense for reasonable chastisement. It wasn't raised in the court case, and the judge actually did note that would be a stronger defense than the arguments that were made, if it was made, but the court didn't rule on that. So it would be up to a future court case to rule on the question of whether religious belief in spanking is a legitimate defense. But this judge has ruled that the general defense of chastisement, reasonable chastisement, is not legitimate. So,
I mean, and just in case for the listeners and for yourself. I mean, just for the listeners and for yourself, I mean, I'm not going to get into the religious nitty-gritty of it all, because I think that either way, that in this particular instance, at the very minimum, wouldn't necessarily lead us to a debate. It would obviously just be divisive, and that some people feel that, yes, it is my religious right and my religious practice to obviously do something of that nature, whereas other people would say, no, it's not necessarily, it's not essential. So I'm not going to get into that particular debate, if you don't mind. What I want to get back to, though, is, I mean, looking at this particular case, I would agree with you that, yes, this case here dealt with assault, if not abuse, in whatever other form, and is probably not the best benchmark for what then becomes a reasonable chastisement. And yeah, perhaps the Supreme Court of Appeal would have a view, if not the Constitutional Court would have a particular view on this particular case. But now going back to it, I mean, you were talking earlier about infringing on the right of people within the home to govern their homes as they see fit. But I mean, surely you would agree with me that is something that the law has been doing for eons now. I mean, for example, domestic violence. Some people would feel that culturally, religiously, historically, they have a right to beat their wives for whatever reason, within whatever reasonable terms they see fit. And yet the law makes it absolutely clear that that's not on, that that's a crime of a severe nature. So, and there's many other examples that I could cite, but surely we can't then turn around and say that now this is a sacrosanct space, this is what happens within the home, and therefore the law doesn't have the opportunity to infringe in that particular space, Philip?
Okay, now let me just draw a distinction here. Firstly, we have laws that come from the common law, which have been in place for thousands of years, which include the right to reasonable chastisement. We have other laws that are made by Parliament where the public is consulted, and now twice in the last 20 years the public has been consulted on proposals to have spanking banned by Parliament, and on both occasions there was very strong opposition to that, and Parliament abandoned the idea in response to the submissions that were made. Now what we have is a single judge who decides to usurp the role of Parliament, which means taking away our vote and our right to make those decisions. Now, certainly we wouldn't defend domestic violence or abuse within the home, but those are extreme instances, and those are laws which are in place existing in terms of the laws that are in place from the common law and also from laws that are made by Parliament. Here we have a judge imposing her own personal agenda and her own personal opinion on the rest of the country without the opportunity for that electorate.
But just hang on. I mean, I think that's a bit unfair. I mean, for you to equate this. I mean, again, going back to what the general public want and how the general public tend to respond to these things, right? I mean, I'll use another popular example, and maybe an unfair example, but nonetheless an accurate example, is, for example, the law on capital punishment. I mean, capital punishment is illegal in South Africa. It's unconstitutional, but if you had to do a snap survey among South Africans, the vast majority of South Africans would agree and probably say that we need to bring back capital punishment, i.e. the death penalty. And the simple reason for that is because we live in a country that is under heavy strain when it comes to crime, Philip. So surely under those circumstances, the will of the majority doesn't always prevail, because we have a constitution, and a constitution on top of it that tends to say what is reasonable and what is unreasonable within a particular context. And that is why we have laws around equality, laws around dignity, laws around certain aspects of what we might even say is a personal aspect of South African life, but yet is still important to govern because it might not be aligned with what is due constitutionality. I mean, surely your argument doesn't work in that instance, where you need to consult with the masses before we decide on whether it's okay or not to spank our children.
Okay, well, just to clarify on the issue of capital punishment, if you want to look up on my Christianview Network YouTube channel, you can listen to the recording of the debate on capital punishment that I had, that was also hosted by your radio station. But to just clarify, the instance of capital punishment was an exceptional case in terms of a decision by the Constitutional Court where the Constitutional Assembly specifically could not reach agreement on the issue and decided to leave that matter to the Constitutional Court. So in that instance, it was legitimate for the Constitutional Court to make that ruling, and that ruling remains in place until such time as a constitutional amendment is passed to clarify the matter, which could still happen in future, but then that will need a substantial majority to pass that amendment to clarify that issue. That'll need probably a 75% majority. Now that is a question where the Constitutional Assembly specifically, deliberately, intentionally left that issue as something that they were not clear on. And the Constitution doesn't specifically outlaw capital punishment, nor does it specifically support capital punishment. It's just neutral on the issue. Now here we have a set of issues which are being pushed through the courts, which were definitely not the intention of the Constitutional Assembly in the early 1990s. I was around at the time. I was involved in lobbying at the time and aware of the debates. But we have a raft of issues coming just this year. The Dacha issue, the euthanasia issue.
Let's stick, Philip,
activist groups are trying to use the court as a lever.
Philip,
yeah.
Let's stick to the issue, and please, let's stick to this issue. We can touch on the Dacha. We can touch on the other stuff if you want to.
I don't want to discuss those other issues, but what I'm saying is
you're introducing them, Philip.
Of legitimacy.
No, Philip, you're introducing them. And I think let's get back to the issue of legitimacy that you're talking about. And that's really what I want to touch on now. Because your understanding of constitutionality versus my understanding of constitutionality. And by the way, this is not just from reading a textbook. This is not just from reading articles on this issue. This is from someone that has an LLB, someone that has graduated, having studied law. My understanding of constitutionality versus yours is extremely different. Because from what I understand, the Constitution, which is, especially if we look at the Bill of Rights, the rights that have been outlined within the Constitution is the basis on which all other laws then are subjected to. So in other words, you don't have sort of this parliamentary supremacy system, and then the Constitutional Court creates law, or any other court for that matter starts creating law through the back door. You have certain laws in place. And I mean, we have a judgment already in place. And I'm not saying that this High Court judgment is necessarily reflective of previous judgments that related to corporal punishment. But we can't get away from the fact that we have anti-torture legislation, that we have legislation that makes it absolutely clear that you can't have unfair processes or inhumane means of punishment, and that in this particular instance, if this matter had to go to the Constitutional Court and had to be argued in that particular way, that you would most likely find that corporal punishment, even within the home, would be declared as being unconstitutional, and that you don't need the involvement of Parliament whatsoever in that particular instance. The same applies. I don't think that there was anything particularly special about S versus Makwanyane, the case that ended capital punishment in South Africa. There was nothing special about that case. That case, whether it happened in 1996 or it happened 20 years later, would have come to the exact same conclusion, that capital punishment, like corporal punishment, is unconstitutional and doesn't have a space in this particular country. And that now we're finally looking at the home, and that they're saying that it's not welcome in the home. I don't think that it's the image that you're creating of this being weird, wonderful circumstances is accurate in the least bit.
Okay, sorry, just for clarification, I did not say that the case was special. I said that the issue was an issue that was left vague. And a key issue interpreting the Constitution is the intention of the meaning of the words, not the meaning that is read in 20 years later by an innovative judge. Now, just to quote Robert Bork, who's one of the legal experts in America, who's a justice, he said, "How are we to be guarded from the guardians? The only answer is that judges must consider themselves bound by law that is independent of their own views on what is desirable. They must not make or apply any policy not fairly found in the Constitution or a statute. It is, of course, true that judges, to some extent, must make law every time they decide a case, but it is minor interstitial law. The ratifiers of the Constitution put in place the walls, the roofs, the beams. Judges preserve the major architectural features, adding only filigree. So the judges can, if something is specifically in the Constitution, they can strike down a law, but all of that really should have been done in the last 20 years. They shouldn't be finding new things now. But otherwise, they should be adding detail on decisions. But here we have more and more walls and rafters being destroyed by judges that are now trying to completely renovate the South African law.
I find your interpretation and your understanding very different from mine, because again, in this particular instance, I will reassert what I've said, and I will re-emphasize what I said previously, is that I don't think that this is anything particularly new, because if I had to be an advocate in this particular instance and I had to approach the Constitutional Court or the Supreme Court of Appeal and explain why it is unconstitutional, why children should not be beaten within the home, I would, number one, quote Section 10 and say it's an infringement on dignity. I would also look at, unfair and unjust punishment within any setting, whether it be in the home or whether it be in any other instance there. So, look, I think you and I will agree, Philip, that we definitely hold two very different views in terms of what the legal interpretation of this is. But second to that, what I'd like to understand from you, and this is more of a sociological question as opposed to a legal question, is that, I mean, surely we should welcome a case like this because it presents us with two opportunities. Number one, whether we should be addressing children's misdemeanors and bad behavior, even a 13-year-old surfing porn, which is obviously not appropriate and a good idea in the first instance, but whether we shouldn't be addressing that type of behavior through, I don't know, talk, and I'm making that young person understand that what you're doing is you're warping your mind with sexual content and that this is not good for you. This is going to create unhealthy sexual expectations in your youth at an age that it's not supposed to be happening at, number one, as opposed to beating the living daylights out of this child. So in other words, what I'm saying is, shouldn't we as parents be finding ways to be disciplining and dealing with our kids in non-violent ways? Isn't that the first opportunity that we're given? And second to that, I just spoke to two different individuals, one of which is working in the space of abuse against children. And she's saying that there is definitely a link between violence or abuse, and not necessarily sexual abuse, but abuse, and the fact that we find so many abusers within our society. So isn't that another thing that we need to really consider and start thinking about and start working against?
Okay, well, firstly, there are many methods in which you can discipline a child, and the spanking is one of those tools in that arsenal to have an influence on the situation. Definitely wouldn't recommend it in every situation. If you deal with a problem more easily through talking to them, definitely do that or as well. But this is taking away a particular useful tool that parents have, and it's really also up to the parent to decide whether they want to do it. If a parent doesn't want to do spanking, they don't have to. It's also a difference between different children respond differently. Some children might not need a spanking to be influenced. There's also the factors of the size of the family. If you have smaller families, sometimes parents can more easily control the children without the need to use strong disciplinary methods. In larger families, there can be more need, or if the child is less responsive to other forms of discipline. So that's a big subject which one could bring in. And I recommend a book called Dare to Discipline by James Dobson, which you can download on Kindle, which discusses all the different ways of disciplining children. But secondly, I would say, no, this is not abuse, but reasonable chastisement is not abuse. But in a situation where a parent does have a problem with abuse or uncontrolled temper, they cannot stop themselves from being violent, then I would say that parent, it would be a good idea for them probably not to spank their child. Maybe let the other parents do the discipline, do that sort of discipline, because if they can't control themselves and they're going to maybe behave like this unfortunate incident in the court case, then he doesn't want that to happen, and that's why.
So,
often I think that, yeah.
So I mean, just to jump in there, I mean, I have a serious problem with what you're proposing there. Number one, number two, let's look at what you're talking about there. I asked a very simple question, so. I'm sure that you and I will agree. Before I even go to that question, I need you to define something for me. What is reasonable chastisement within the context of a spanking? What is reasonable chastisement? Please explain that to me, because I'm not quite understanding.
Okay, well, I'd firstly say that if you look at the discussion in Dr. Dobson's detailed book on the subject, you'd see that a very small child is a fragile person, and one has to be much more gentle in dealing with them. Maybe spanking is not appropriate below a certain age. It also maybe above a certain age becomes inappropriate in terms of the other issues, such as just the way that you deal with a child. But I think a major factor is one doesn't want to cause any sort of injury. It's just one wanting to use physical discipline as a mild form of pain. Emotional pain is also causing pain, as if people are not using physical discipline, they will cause other harm to the temporary short-term harm to the child, maybe removing privileges or putting them in the room for a little while, and just using moderate physical discipline, which doesn't cause any sort of injury, is reasonable chastisement. That's the understanding of the common law.
Okay, so looking at then this issue of reasonable chastisement, I mean, even reasonable chastisement, I mean, surely you will then concede that it involves violence within the context of spanking. Because, I mean, reasonable chastisement for me is, for example, sitting down with Mikey and telling him that, listen, you have to take a time out. You have to sit in that particular corner. And he'll initially probably have a little giggle, which will probably annoy me a bit. But after a while, he'll realize that, you know what, I can't play with my favorite toy, or I can't watch my favorite cartoon, or I can't interact with my, with my brother while I'm sitting here on this chair, and it's been a good 2 minutes, and I'm really getting annoyed, and I'm getting uncomfortable. So in other words, he wants to, the next time he's naughty and I tell him, listen, I'm going to give you a timeout, he wants to avoid that timeout at all costs. So surely there is an option, as opposed to me, 6 foot, 96 kilograms, reasonably chastising a 3-year-old. I mean, surely. And I'm not even talking about, beating the living daylights out of a 3-year-old. I'm saying that surely I don't necessarily have to resort to any form of violence, no matter how light this violence may appear to be.
So firstly, I'm not telling you how you must discipline your child. That's your choice. And it's also up to every listener to decide how they're going to do it. And secondly, certainly any form of discipline, the lighter the manner that you can solve the problem, the better. But this is an alternative which parents need to have as that they can use if it's necessary.
Just hold for me, because I have Janine on the line. As I said right at the beginning of this conversation, the lines are open. You can come in 011 883 0702 or 31702 for your SMSs, 072 702 for your WhatsApp messages. It can be text messages, alternatively voice notes. If it is a voice note, keep it short and sharp. That's 072 702 1702. And then finally, hashtag talk at 9 for those of you on Twitter and Facebook as well. Let me go to Janine quickly in Alberton. Janine, good evening.
Hi. Just, I do believe in spanking. I was brought up, I was spanked on many occasions. Maybe I was very naughty. But I do believe in spanking. I think it is a form of discipline. I think it is definitely how it is handled by the parent. I'm not a parent, and I'm in my 50s. I've not had children. However, if I had children, difficult to say how I would have handled it. I don't know. But I certainly don't disagree with it. I think it is a definite way of discipline, and I do think that it does instill some form of discipline. I mean, what is it? Well, it's a form of discipline.
Just a quick question.
I certainly do.
Just a quick question there for you on that one, Janine. And then, Philip is also, once you're done with us this evening, maybe you can also come in on that one afterwards. But what I just wanted to find out from you is, I mean, in your instance, what you're insisting on is that, listen, you were spanked and you were disciplined. So in other words, your parents were reasonable in what they did, that they were caring in what they did, right? So that's what I'm taking out of that. Am I correct?
I think so, yes.
Right. But, I mean, do you think, and this is where I'm concerned, do you think that all South African parents, or all people that are in the space of South African parents who then use, spanking as a form of discipline, can say that, confidently that yes, they are, that they would be reasonable and measured in how they.
No,
exactly.
You see, that's how we don't. It is a problem in terms of where do you draw the line. Now, I grew up I went to school, and we had canes at school. I mean, I remember the guys at school being caned.
Mm. I used to get caned. Believe me, I remember those days.
So if there was I do believe it has to be something like quite major for you to be caned. But I don't think that it's not, what's the word? I mean, there are advantages and disadvantages in it. But I certainly don't think it should be abolished. I really do not believe it should be abolished. I think there is definite positivity in caning, or you know. I mean, if I can tell you, my father used to take a belt to me, and at one point, and then it was a cane where I literally had to bend over, and depending on the severity of the offence, I took 2 canes, 3 canes, 6 canes, whatever the case may be, both my brother and myself. And both my brother and myself would agree that we're not sorry today.
Okay, no, 100%. No, I appreciate your call. All the best to you, okay?
Thank you.
Great
Bye-bye.
one. That was Janine. Philip, just hold for me because I see that the calls are coming in quickly. I'll just take a couple back-to-back. Cuba I hope it's Cuba in Santon. I hope that's how you pronounce it.
Yes, that's correct. It's the first time I'm dialing in.
Oh, great one, man. Thanks for joining us.
So I think that Philip is defending corporal punishment. Am I correct?
Yeah. And Philip, is that a correct assessment?
Through the discussion.
Yes.
Sure.
Look, I think that corporal punishment has no place in a modern society. My parents never ever punished me in that way, and I've turned out quite well. South Africa should aim to become a modern society. I think the law of the land is set by the courts and by the Constitution, and that is the supreme law of the land. And I really see no argument with that. Modern societies have moved past these barbaric punishments. And I really don't see this having any place in South Africa, in a modern country, in a modern democracy, and in a modern world.
Can I just ask you quickly? I mean, you said that you weren't spanked as a kid, right? You turned out okay. You didn't end up sort of a deviant within society?
Yes, that's correct.
But I mean, what forms of punishment then? Because you were also not a perfect kid, but no one ever is. Well, how were you punished as an alternative?
I wasn't really punished, but I did grow. I simply grew out of it and became a responsible adult.
Okay, sure. Thanks for that one. Thanks, Cuba. All the best.
Okay, thank you.
Cheers. Bye. And then last one, let's go to Vani in Randburg. Vani?
Hi, Gushwell.
Hi.
Thanks for taking my call.
Only a pleasure.
Great. Yes, I do have an opinion on the matter. I'm a registered social worker, although I haven't been in practice for many years. But I still stay in touch. And my view is that it is a very fine line that one is crossing when one decides to exercise any form of corporal punishment on a child, because one has to ultimately be saying we're leaving it in the hands of the parents, and where does one actually draw the line when it comes to the child abuse. Please forgive me, I need to move the cell phone away.
Please, because I was about to say I'd hate to drop the line now.
Sorry. I've kind of moved it away. Yes.
Good, yeah?
Yeah, so in my view, in leaving that, thinking that chastisement is okay, in my view, it's not okay. There are many other ways in which one can discipline a child. And what it does take is effort on the part of the parent. It takes some education. It means that you actually have to go and seek information on how to discipline the child, rather than resort to what seems like the easiest way. And I recall often telling parents when we did parent effectiveness training, saying to them that our children are just little people. They're big people in little bodies. They just can't actually defend themselves. And if we're saying that it's okay to hit a child, to correct them, then why do we say that when one adult wants to correct another adult, that hitting is not okay? How can we draw the line there? It's okay for you to hit a child, but it's not okay for you to hit a grown woman. To me, it's one person physically assaulting another person. It's a child that child will remember that the same hands that touched me lovingly also hurt me. And that's how women feel when they're physically abused. The same hands that claim to be loving me is hurting me. How is that? So children actually do remember. I recall the hidings that I got when I was a kid. I didn't like it at all, and our jobs as social workers is to protect children. And yes, when we end up in a court and it comes to physical abuse and one needs to talk about the degree of the abuse or the degree of the neglect, etc., it's a really, really fine line, even for a commissioner sitting in a children's court, as to whether to say, yes, okay, it's okay to chastise your child. But really, I can say this with my own two children, one had to find the balance, and one had to find, and not balance between chastisement and any other form, but between the other different forms of discipline that we engage in with our children. And it does take time. It does take effort. Too much discipline is not good. No discipline is also not good. You've got to find the balance in terms of how we're going to exercise this discipline. And I'm sorry, but there is no argument, in my opinion, in favor of physically chastising a child.
100%. Listen,
yes.
I think you spoke clearly. I think you made your point. Thank you so much, Vani. All the best to you, okay?
Good.
Cheers, man. That was Vani. Final one, then I'm going to take Tash in Germiston. Good evening.
Hi, Gash. A quick one, man. Gash, I think maybe we need to differentiate between giving a hiding and abuse. Some of these kids that are growing up in here, they don't have toys where we can say the punishment will be, I'll take your toys, go to your room, you don't have toys. They don't have. It
doesn't just have to be toys, my friend. You know that.
No. I'm just saying. I'm not saying. That's my point. I'm just saying that. I was given a hiding. I don't believe I turned out that bad. I don't abuse people. I still love my mom to bits, even though I know, obviously, she gave me the hiding. But I think the logic that because some people do abuse kids, now we have to ban giving your child a hiding. I think it's going overboard. Guys, we know people abuse alcohol all the time, but we don't ban alcohol because, some people abuse it every day. We find a way of dealing with it. If people are doing it responsibly. Remember, when your parent is giving you a hiding, it's supposed to be a hiding with love. It's given with love. It's to show you that.
But I'll ask you the same question I asked a couple of people, Tash.
Yes.
Again, I'll ask this question. Surely you will agree with me that not everyone is in the position to give a hiding with love. You in Germiston there, do you tell me that every parent that gives their child a hiding gives a hiding with love or an intention of love or, in such a way that one wouldn't say it's abuse?
The simple answer is no. Like I gave you an example of some people, they drink alcohol and they abuse it. But that doesn't mean everyone in Germiston is doing the same. So we can say because someone is doing it as abuse, then everyone is not supposed to do it.
Okay. No, fair enough. Thank you for that. Thanks. All the best to you, man. That was Tash out of Germiston. Philip, you heard the various calls coming through. I, in my opinion, and I'm going to highlight my bias. Obviously, Tash's call stood out for me the most.
Okay, well, I'd like to respond to this issue firstly about violence. I think a point has already been made by the caller that the previous caller that there's a difference between violence and abuse and loving discipline. But I'd also like to raise the issue that if one does not discipline people properly, there is a greater risk, and not in all instances, and obviously with respect, not the callers that have called in now, that the person grows up as a delinquent who has not been disciplined. And if one looks at people who become criminally violent in later life, very often one of the problems in their background is that they have not been disciplined by their fathers when they were younger, very often because those fathers were absentees. We have a situation where grown men are afraid to go home at night on the train in the dark because they might be assaulted by school kids who are violent. Now, why are those children violent? They are not being disciplined properly. So it's not just a case of a risk of discipline turning into abuse, but failure to discipline can turn into violence as well. And the scripture, just say, Proverbs 13 says, he who spares the rod hates his son, but he who loves him is careful to discipline him. There's another 5 Proverbs which say a similar thing.
You see, when we go down that line of argument, I agreed with you right at the beginning, Philip. We're not going to go down the religious route because I can quote other scripture that was written at around about the same time that many of us as Christians don't necessarily practice in this current form. So let's not go down the religious route, because quite clearly that is going to cause a lot of division and a lot of disagreement. I'm pretty sure you would agree with me on that. So let's get back to the hard facts, the hard issues in front of us. The fact of the matter is, but when you raise your hand to your child, no matter how lovingly you're doing it, it is a form of violence. I mean, that for me I've never heard of a non-violent spanking. I've never heard of a non-violent belt lashing. I've never heard of a non-violent pinching under the thighs or ears or whatever the case is when you resort to those forms of discipline. Again, it's something that I can't agree with. It's violence.
So, well, look, there's two issues there. The firstly, it depends on your definition of violence. Look, if you
no, mate, let's agree then that we don't have the same definition.
If you psychologically assault somebody, you can cause a very serious injury to that person without touching them. And so,
Philip, can I ask you a very simple question, just quickly?
You shouldn't be allowed to talk to somebody as a form of discipline to not hurt them. It's just
no, Philip. Let me ask you a very simple question, right? So you work for me, right? I'm your boss. I'm your manager of some sort. So I don't know, what industry are you in, Philip?
Okay,
I'm asking a question. Just answer my question there. What industry are you in?
Okay, look, I've spent most of the last 20 years working as an environmental consultant. At the moment, I'm working very much on tackling these particular issues.
Sure. So let me finish my question then. So you're an environmental consultant, right? So what you then go ahead and I ask you to do an environmental assessment within a particular area. You come back with your assessment. I look at the report and I'm not happy with the report. And because I am your boss, because I'm in a position of authority, I'm not happy with it. And then I take you, I put you over my knee and I give you a solid spanking. Philip, what would be your response?
Okay, now look, that's an entirely different situation, because now you're talking about a person who doesn't have any sort of authority to do that. The situation within the home, the relationship between the parent and the child of a minor child is an entirely different situation. In a work context, a person has various forms of discipline that are open to them, that they can make use of. They can fire the person, they can demote them, they can they can take them to court or whatever. But those options are not open in that situation. I think there's a very big difference there.
I really don't think that there's much of a difference, Philip, in the two examples. But anyway, if you insist. Looking at some of the SMSs that have coming through, via the SMS line on 31702, because I need to read some of these as well. Someone says here, Moabi, saying pretty much in agreement with you, saying he's from the Vaal, saying, evening Gushwell, the next thing we know is that the courts would be telling what and what not to feed my child. And this is from MJ Sepepi, or Mohabi, as he said. Looking at some of the stuff coming through also, but now the thing is, a lot of one-liners, guys. Don't send me a lot of one-liners. Just send one single SMS. That would be so much better. Looking at WhatsApp as well, there's also a couple of WhatsApps that have come through. Someone says, hi Gush. People who quote the Bible or any other religious script on this topic often, I believe, are just downright lazy and unimaginative. Why? If to be Christ-like is the ambition for us as Christians, why do we often find ourselves conveniently forgetting to follow the other doctrines like love one another? This is what someone has to say on that one. Someone says a parent who disciplines his child in a form of corporal punishment does not mean that a parent is abusive or disciplining them with intentions of abusing them. I agree with that, and it's very true. Look at how Julius Malema turned out. He was never spanked, and this is what someone says. Well, I think that Julius actually turned out pretty well, despite his politics and whether people like it or not. Final question, final call that I'm going to take quickly. Let me take Alan from Somerset West, all the way in Somerset West in the Western Cape. Let me click on his name. Alan, good morning. Oh, good evening.
Hi.
Sorry.
Yes, can you hear me okay?
Yes, I can hear you okay.
Yes, thank you. I just wanted to make a few points. There was a caller a little while earlier called Cuba. said that corporal punishment has no place in modern democracy. One thing I just wanted to respond to that is that hidings for children are illegal actually in all 50 of the U.S. states, and they're even legal in Canada. The thing is that if you use the word corporal punishment, it comes with heavy connotations of violence. But actually a hiding is something very different to that. I would disagree with you in saying that all hidings are violent. I mean, where are you going to draw the line? If you say to your child, no, don't do that, and you raise your voice, are you going to say that that's sort of verbal abuse, or is just, that's just appropriate discipline?
Well, I think I can draw the distinction because I regularly verbally abuse people on a day-to-day basis, whereas when it comes to my 3-year-old, when they misbehave, I tend to not use those words that I verbally abuse other people with all the time.
Well, you do raise your voice, right? So where are you going to draw the line? So
I raise my voice against my boss as well.
What I wanted to say is also just to affirm the book that Philip recommended for people, which is by Dr. James Dobson, a very respected psychologist and author in the U.S. and the founder of Focus on the Family. And I think that different from child abuse and violence, hidings are actually a very loving thing to do for your children, not a violent thing to do if they're appropriate. So Dr. Dobson recommends that you not give hidings below the age of 18 months, and he also sets an upper limit where above a certain age, people will actually become more resistant and more rebellious if you give physical hidings. But there is definitely a certain age, but not only the age restriction, also the situation. It's not for every child. I think your son sounds like a very compliant youngster.
No, he's not,
he just
actually.
giggles and becomes sort of bashful if you chastise him verbally, and that's great. But Dr. Dobson's also written a book on the strong-willed child, which is a particular class and category of difficult to discipline children.
Which my son falls into. Ellen, listen, I appreciate the puns on the books.
Let me just finish.
Ellen, time. No, listen, Ellen. Okay, fine. Ellen is not willing to listen. I have time limits here. I can't be listening to a long list of books that are coming out. Philip, I'm having a very, very focused and serious conversation with you around this issue of spanking, about chastisement and discipline, right? And with all due respect, I really appreciate all the advice on the books and everything else that has come through, and that is great to hear that there's all these books out there providing guidance. My final issue that I want to tackle with you is on this issue of parental care and what it means to be a good parent. So yes, I do believe that there are some parents out there in this world that can give their kids corporal punishment, that can hit their children, and do it in a loving way, in a caring way. What my concern, though, is that I'm worried that we live in a country where that is not guaranteed. And if that is not guaranteed, then surely at some stage we need to intervene on a legal basis. How do we then deal with the amounts of abuse that we have? I mean, I've seen how many social media videos going around, despite the fact that there's a ban on corporal punishment in schools, of teachers whipping children in school, of kids popping up with horrible bruises and beatings and all kinds of other things that they've suffered. How do we deal with that? How do we balance that then?
Well, certainly the existing law allows for people to be prosecuted for abuse. For example, if they cause serious injury, such as in the situation of this court case, which should have happened, with 4 days later the child is showing injury, and that should continue. There should be no change there. I also don't think that this law is actually enforceable or will be enforced. I think the government has failed to enforce even the corporal punishment ban in schools, as you have just referred to, and even more so, they will fail to enforce this ban. All it's going to do is to criminalize good parents. And the government has completely failed to enforce the law for the safety of its general citizens, and should concentrate its resources on solving these other problems. But just to also respond to one of the issues that's raised there previously, I think there's a framing of the issue as a pitting of a religious viewpoint against the views of psychologists and whatever. Now, these psychologists also are coming, and lawyers are coming from an ideology which is just their worldview or set of ideas, which I think should be balanced by the views of traditional religious ideas and traditional cultural ideas as well.
Yeah, but I mean, traditional religious and cultural views are under dispute as we speak at the moment. You know, when some bloke, I don't know, somewhere in the forests of Uganda decides that religion informs him that he should be kidnapping a bunch of kids and turning them into child soldiers, or if some other dude in the Middle East decides that, you know what, he wants to start his own caliphate because of his religion and culture, then we're also worried about that. So I don't necessarily think, Philip, again, going back to the whole issue of what the problem with religion is anyway. And I'm a religious bloke, by the way. I'm a guy that has beliefs, and I go to church and I have a certain set of beliefs, but I don't see those beliefs, as much as they're beautiful and they're great and they probably, it could be argued that they should be universal. I understand why they're not universal and why I shouldn't impose my will on other people and say that this is the way we have to do stuff.
Yeah, no, sure, but this lawyer is bringing an ideology that she was taught probably at university and attempting to impose that on the majority of South Africans who don't share that belief. And, our response is, well, sorry, we don't believe that, we don't agree with that, we have a right to our belief and what we are practicing, and that this was never intended by the Constitution, and we don't want her to impose her religion on the majority of South Africans.
Okay, Philip, let's leave it there. Philip believes that this is a judge that